28, Senator DeSaulnier, and item number 5, SB 1393, Senator Simitian. Again, we're going to be taking testimony from 2 witnesses for and 2 witnesses against each bill, with each having 3 minutes to speak. Other witnesses will be asked just to state their name, their organizations, and their positions for the record. Also, I ask everyone here, including the chair, to shut off your cell phones or texting. This is a hands-free committee. And Mr. Ashburn likes it when I do this, Senator Ashburn, when I go there. And so turn off your cell phones. Take conversations out of the committee room so that we can hear the testimony that's presented when members cast their vote. Our first author is Senator Cedillo, presenting SB 1216. Welcome to the committee, Senator Cedillo. And I do hope that you feel better.
Thank you for your accommodation. I want to commend the minority analysis on this. I think it's comprehensive, thorough, and on point. It's good work. It's good work.
And what about the majority analysis?
Well, of course, the majority analysis it's always good.
Thank you, Senator Cedillo.
I don't have to tell anybody about the need for us to do all that we can to improve our economy, to create jobs, to get construction on the move. Everything we do should be focused on jobs, jobs, and jobs. This bill, modest as it is, would be a step in that direction. What SB 1216 does is it creates flexibility and the ability for us to trade and swap federal and state tax credits for eligible low-income housing projects. That's it. Straightforward.
Thank you, Senator Cedillo. Before we go further, I would like the Secretary, we have a quorum present. I'd like the Secretary to please call the roll.
Lowenthal.
Here.
Huff. Here. Ashburn. Present. DeSaulnier. Harmon. Kehoe. Oropeza. Here. Pavley.
Both.
Simitian.
Well, thank you. Witnesses in support.
Holly Fermini, with Platinum Advisors on behalf of the Pacific West Communities. They're an affordable housing developer, and with this flexibility, they are in a unique situation where they do have some investors that would exercise this option if the flexibility was given to the Treasurer's Office. We urge your aye vote.
Thank you. Other witnesses in support?
Mike Kelly with Pacific West Communities, Director of Finance and Acquisitions in support.
Alex Chavez on behalf of the State Treasurer's Office here in support of SB 1216. I also have with me Mr. Bill Paveo from the Treasurer's Office. Mr. Paveo is the Executive Director of California Tax Credit Allocation Committee and is available to answer any technical questions the committee may have. Thank you.
Thank you. Are there any other witnesses in support? Are there any witnesses in opposition?
And there.
Not seeing any opposition, I bring it back. The bill has been moved by Senator Ashburn. Is there any other discussion or any questions by members of the committee? I think it's a bill that's overdue. It really does help us in our promotion of affordable housing, and the chair is pleased to support the bill. With that, would you like to close, Senator?
Ask for an aye vote.
Thank you. Will the Secretary please call the roll?
Lowenthal.
Aye.
Huff.
Aye.
Huff, aye. Lowenthal, aye. Ashburn.
Aye.
Ashburn, aye. DeSaulnier. Harmon. Kehoe. Oropeza. Oropeza, aye. Pavley. Simitian. Simitian, aye. 5-0.
Yes.
Bill has 5 votes. We will keep the roll open for the absent members, but that is sufficient for passage. With that, let's do the consent calendar. We have 3 items on the consent calendar, items 8, 9, and 10, SCR 54 by Senator Cogdill on the Kurt Lindsay Memorial Highway, SCR 83 by Senator Negrete McLeod. Yes. Would you like to pull?
Mr. Chair, I'm not interested in pulling any of the items. I wonder what the appropriate process is for me to comment on all of them. They're all about highway naming, and I wanted to just share some thoughts about highway naming.
I think this is the appropriate time to comment.
All right. I will support this consent calendar today, of course. But I must say that I am concerned that I don't know how long it's been since we've looked at our criteria for the naming of highways and bridges. But, and this is not to speak, I'm going to speak generally about naming. It's my belief that we ought to allow or provide for some kind of a, I don't know what you would call it, a cooling off period, or I don't know what you would call it, but a period in between which, when somebody passes and we provide for the naming of that individual highway. Because often in the heat of the moment of somebody's passing, emotions run high. Mm-hmm. And I think sometimes we may feel moved to make decisions about the naming of a highway or a bridge for an individual that, if a little time were given, it might not be as obvious a choice. Let me put it that way. In the past, and I know we have criteria, and a lot of that criteria is really excellent. In fact, all of it is excellent. What it doesn't address, though, is any kind of a time period for waiting. I don't think we require that the individual have passed away, actually. And I think that we might want to, at some point, in some way, revisit the question of should this be something that is only given to people, that this honor being given to people upon their passing, or not? That's a question. And then, if the answer is yes, what time period should have passed? In most cases, as I recall, in the recent past, it has been an honor bestowed upon people who have passed on. But we have not looked at any kind of... So they can have passed on just a few months ago, and we go ahead and do the naming. So I don't know how else to shape that issue, but to be direct and to say that I think we ought to take a look at that aspect of our criteria and see if we shouldn't... I know it's a touchy and delicate situation, but I guess I would suggest that at some appropriate point, Mr. Chair, we have either a discussion or some kind of a relook by the chair and his staff or whatever at the policy that we have.
I think that's totally appropriate to raise that. I think that we should always be re-examining some of our policy decisions, especially about guidelines, about naming. I think what we can do is to make sure that everybody has a copy of that,
yes,
of the rules, and then to make comments, and then to meet, maybe to have some discussion set up sometime. I think that's... I would be very supportive of doing that,
Thank
Senator.
you, Mr. Chair. Thank you. And I'm happy to move consent if you would.
Okay, in the back...
They're in there under the committee rules.
All right. So there, see, I didn't even know that that they're in the back of our binder, our rules and policies. But I'd be willing to have everyone make comments on it if you want suggestions back to the chair, and then we can have to the chair and to the vice chair, and then we can have a full discussion or at some point. I think that'd be totally appropriate. Now, yeah, let's go forward with the consent calendar. Which is SCR 54, Senator Cogdill, SCR 83, Negrete McLeod, SCR 84, Senator Anistad. Senator Negrete McLeod was the ninth. That's items 8, 9, and 10. I will entertain a motion to pay for the consent calendar.
What about the technical amendments? You want to mention that on both of those, too?
There are technical amendments in items number 8 and 10. So with that, the consent calendar has been moved by Senator Oropesa. Will the Secretary please call the roll?
Lowenthal,
Aye.
Lowenthal, I. Huff. Huff, I. Ashburn. Ashburn, I. DeSaulnier. DeSaulnier, I. Harmon. Kehoe. Oropeza. Oropeza, I. Pavley. Semidion. Semidion, I. 6-0.
Good. We now, that too, the consent calendar has 6 votes, sufficient for passage, but we'll hold the roll open for the absent members. All the remaining items on our agenda are committee members. Senator Semidion, would you like to present? Senator Kehoe, it's the Semidion and Kehoe show today. Senator Semidion has 2 items, and Senator Kehoe has 2 items. Let's begin with item number 3, SB 1268, toll bridges and highways, electronic toll collection.
Thank you, Mr. Chairman and members. First, let me begin by thanking the committee staff for their work on the analysis and assistance with amendments. I think we've ended up with a tighter, more rigorous bill as a result, so thank you very much for that. This measure, SB 1268, protects the privacy of California motorists by controlling the use of personal information that's collected and stored by electronic toll collection systems. Just to be clear in terms of what kind of information we're talking about your travel pattern data, your location, your speed, your time of day, your address, your telephone number, your email address, your bank account information, credit card numbers, all these kinds of things that are collected and retained in a typical toll collection system. The measure does 4 simple, but I think key things in terms of providing some increment of privacy protection. First, it prohibits the sale or dissemination of personal data collected by transportation agencies. In other words, when you run past that bridge and the data is collected, it prohibits the sale or sharing of that information. It should stay with the place that has collected. Number 2, it limits how long that personal data can be retained. One of the key issues in terms of data retention and privacy is particularly in a world where it's increasingly free to keep data forever and ever and ever, this data gets stored digitally and there is no requirement that it ever be purged. It can be retained year after year after year. This measure limits how long personal data can be retained. Number 3, it requires conspicuous and meaningful notice to subscribers of transportation agencies' privacy policies, so you know what privacy protections you do and don't have. And number 4, it provides a civil remedy for drivers whose personal information is improperly released to recover damages, reasonable costs, and fees. I believe the bill is necessary because existing restrictions on information sharing and the sales of personal information, if they exist, are simply policy-level decisions that have been made, and they vary between transportation agencies across the state. I think what I will do, Mr. Chairman, is just indicate that while I think the technology we have that's developed is great, I think there are privacy implications that are related to that technology. I think we need to be mindful of that, provide people reasonable choices, give them the options, but make sure that their privacy is protected along the way. This measure will assure that the important privacy protections are codified in statute and extend to all transportation agencies that have or may in the future require electronic data collection technologies. We do have witnesses, and I will ask Valerie Small-Navarro or Li Qian to begin.
Well, just before you do that, I would like to encourage you, as this bill moves forward, we're not going to be requesting any amendments now because we don't, but that, and the committee is supportive of your position and the time frame that you've done in terms of the retaining of information. But we are also aware that this is a complicated issue and that there are legal settlements that have been done before, that are out there that have that require the agencies to retain information for much longer periods than that. We would strongly encourage you, just to keep this consistent as the bill moves forward, to work with those agencies to come up with some kind of arrangement, because I'm sure it'll be raised. How does this interface? And what the committee would like to do, I think it's been raised in the analysis, would like you to do is to work on that as the bill, if and when the bill moves forward.
Thank you, Mr. Chairman. Mr. Chairman, as you know, but other members may not be mindful, the bill is double referred. We're headed to judiciary. I think that presents us with another opportunity to tweak the language on some of these technical issues. And
we're not asking you to do that in this committee, nor do we have a solution to that issue right then in this committee. But we know that as the bill moves forward, you will need to resolve some of these issues. With that, witnesses in support.
Thank you very much, Chairman Lowenthal, Ranking Member Huff, and members of the committee. Thanks for letting me speak today. I'm a senior staff attorney with the Electronic Frontier Foundation. My name is Lee Tien. We are a nonprofit public interest law firm based in San Francisco that specializes in high-tech civil liberties issues. Location privacy has been an issue for EFF for quite a few years. Systems that create and store digital records of people's movements through the public space are being woven into the fabric of everyday life. Now, tracking people in public used to be expensive, but today it's not. Location data is quietly collected by ubiquitous devices and applications, and it's this transformation to a regime in which information about your location is collected pervasively, silently, and cheaply that we're worried about. Ordinary people should be able to drive about in public without being tracked in this way. We've already seen how divorce lawyers and law enforcement can easily obtain records from toll agencies. A 2007 Oakland Tribune story, a lawyer was quoted as saying, with the fast track data and maybe credit card receipts, you can put together anybody's life every day. This is only going to get worse as more people use fast track and as more miles of roads in California are covered by fast track. Insurance companies, employers, and data brokers are all going to want to collect this data about us. Now, the ballot initiative that created California's constitutional right to privacy, showed that Californians were concerned about the accelerating encroachment on personal freedom and security caused by increased surveillance and data collection in contemporary society. We believe that SB 1268 will help protect Californians' constitutional right to privacy. Data about our travels will not be sold or shared without good reason, and this fits with the constitutional concern with improper use of data properly obtained for a specific purpose, such as the use of it for some other purpose or the disclosure of it to third parties. People use fast track to get through traffic faster. They shouldn't have to give up their privacy when they do that. SB 1268 also limits the retention of travel data, which fits with the constitutional concern about overbroad collection and retention of unnecessary personal information by government and business. And finally, there's a real need for these protections to be codified into law. In a 2002 New York Times story, MTC commissioners tried to deflect privacy concerns about fast track by saying that there are many safeguards to ensure anonymity and that it would never become a tool of law enforcement or prying eyes, and that all data about individual cars will be purged from the computers every 24 hours. Well, that just can't be true if divorce lawyers and law enforcement are actually using these records. So for these reasons, we support Senator Simitian's bill.
Other witnesses in support?
Amanda Sheldon on behalf of the ACLU in support.
Holly Fermini with Platinum Advisors, excuse me, on behalf of the Golden Gate Bridge Transit District in support.
Lenny Goldberg for the Privacy Rights Clearinghouse in San Diego in support.
Paula Labrie on behalf of AAA in support.
Good. Are there witnesses in opposition?
Mr. Chair?
Yeah, let's wait for the other witnesses to come up. Thank you. Now you may begin.
Mr. Chair, members of the committee, Chris Walker on behalf of the Transportation Corridor agencies in Orange County. We do not have a position, so I don't want this to be seen as an opposed testimony. The board has yet to meet to take a formal position on this bill. I do want to relay that the operations staff do have some concerns about potential impacts on the operations if, in fact, the data has to be purged as per the guidelines in this bill. As the committee analysis identified, the Transportation Corridor Agency is beholden to a court settlement that requires us to retain this information for 5 years. We've been in active discussions with the author's office and believe that we can come to a mutually agreeable solution to that as the bill moves forward. But I wanted to make sure the committee understood that TCA had some potential concerns, was working with the author's office.
And so does the committee, and we have already encouraged that the author has committed to working these issues out. Other witnesses in opposition.
Yeah, good afternoon, Mr. Chairman and members. Paul Bauer with Mercury Public Affairs on behalf of MTC. I would just associate my remarks with the remarks of Mr. Walker and the stated position of the committee that we look forward to working with Senator Simitian to address some of these more technical, practical, how do we work it out type stuff moving forward.
Good.
Excuse me, Mr. Chair. Chris McKaylee on behalf of South Bay Expressways. We are not in opposition. We have met with Senator Simitian and staff and continue to work on addressing the concerns that have already been outlined, but we're not opposed. We just want to clarify some of these issues. Thank you.
So there's nobody that's really in opposition, but people do feel that these technical issues need to be worked through as the bill moves forward. All right. Members of the committee, any questions? Bill's been moved by Senator Oropesa. Senator, would you like to conclude?
Ask for an aye vote.
Will the secretary please call the roll?
Lowenthal.
Aye.
Lowenthal, aye. Huff. Ashburn. Aye. Ashburn, aye. DeSaulnier. Harmon. Kehoe. Aye. Kehoe, aye. Oropesa. Oropesa, aye. Pavley. Simitian.
Aye.
Simitian, aye. 5-0.
Bill has sufficient votes for passage, but we're going to hold the roll open for the absent members.
Thank you, Mr. Chairman. Thank you, members.
Senator Huff, aye.
Thank you, Mr. Huff.
Bill has
Aye.
6 aye votes, sufficient for passage, but we'll hold it open for the absent members. Senator Simitian, you have one more bill, SB 1475.
Thank you, Mr. Chairman and members. A brief bit of history. Members will recall that Thank you, Mr. Chairman. Members, you may recall that in the year 2006, the state legislature passed and Governor Schwarzenegger signed into law hands-free legislation, which requires California motorists, if they're going to have a telephone conversation while they're driving, to do so hands-free. There was a delayed implementation on the bill. It did not take effect until July 1st of 2008. That was to give the motoring public an opportunity to get ready, let DMV and the Highway Patrol prepare, put the information up on their web pages, make sure that there was adequate public notice, and also to let the technology, frankly, catch up with the state of California law. I think ultimately that was a good judgment in terms of a smooth transition to hands-free July 1st, 2008, and then the no texting law also took effect on January 1st of 2009. Before I get to the crux of the bill, which is an effort to toughen the penalties up a little bit, I think it's probably helpful and important to talk a little bit about how has this worked out for us. I felt as the author it was important that my office and I monitor the results, take a look at what the results were, and then come back a year and a half, 2 years later and say, here's what we think might make the law work somewhat better if we had some ideas along those lines. The good news, members, is that in the immediate aftermath of the passage of the hands-free law, both fatalities and collisions dropped by 20% as compared or contrasted with the 3-year average or 5-year average prior to that time. That means fatalities were down by roughly 700 per year, and that means that collisions were reduced by 75,000 to 100,000 per year as compared or contrasted with past years. Now, can we prove a causal relationship between the passage of the hands-free bill and those results? I don't think anyone can prove it to an absolute certainty. But what we can do, and did do, is take a look at the CHP data that year after year after year, beginning in 2001, had tracked cell phone conversations and other distracted driving accident causes. And what we discovered was that in the sample where folks actually identified the basis for their distracted driving accident, there was a 40 to 50% decrease in the number of accidents that CHP recorded as being attributable to distracted driving by virtue of a cell phone. Interestingly, there was not a comparable decrease for other distractions. So the other distractions that we all talk about and worry about, like arguing with the kids, telling the pet to sit down, turning on the radio, all of those stayed at about the same level, while these went down 40 to 50%. So I think we have good results, and I think the numbers are very encouraging, and they're consistent, by the way, with what was anticipated when the Public Policy Institute of California, PPIC, did a study just before the new law took effect. They projected, based on the experience in other states, that we would see 300 to 900 fewer fatalities, and in fact, what we saw was 700 fewer fatalities on an annualized basis. So that's the good news. All of that being said, however, in both my conversations with constituents, anecdotal observation, and my conversations with law enforcement, including CHP, who is here today to be a resource and who we've worked with very closely and who I want to thank for their help, there seems to be a fairly widespread consensus that while compliance is good, it could be better, that there's still a fair number of folks out there who are still clutching that cell phone to their ear, still texting, notwithstanding the law on the books. One of the reasons that may be the case, we think, is because the fines or penalties that are currently in place are relatively small, $20 for a first offense, $50 for a subsequent offense. Keep in mind, of course, that's just the base fine that applies on these bills. What this bill does is it says, let's see if we can't have a punishment that fits the crime, that is somewhat more significant, but not out of range in my view. $50 for a first offense and $100 for a second offense is what we've proposed on the hands-free bill, and a straight $100 offense for texting while driving, which I would argue is substantially more serious. Now, I think the fair question is, are those appropriate and proportional to the risk and the safety involved? Let me just say, Mr. Chairman, that the $50 first offense for a cell phone, for example, compares or contrasts with things like a $100 fine for littering while you're driving your car, a $100 fine for pulling into the carpool lane, a $100 fine for riding in the trunk of your car, by the way. $50, half of that amount is what I've proposed for what is clearly a safety concern, and it's just half the amount that those three, just as examples, carry in the way of fines. We've also made an effort here to correct what was simply an oversight back in 2006 by applying the prohibition to bicyclists. Ordinarily, as I think most of you know, the code simply applies the code across the board to cyclists. There was a drafting fluke, if you will, in the 2006 language that precluded cyclists from being subject to the same requirements. We attempt to correct that here. That's the guts of the bill, Mr. Chairman. I appreciate a chance to present the bill here in committee. I think we have a good law on the books. I think it is saving lives. I think it is preventing collisions. But I think with a more significant deterrent, we could save even more lives and reduce the number of collisions. I would respectfully ask for an aye vote. We have witnesses in support.
Witnesses in support.
My name is Eric Nelson. I'm a Stockton police officer. I'm not here representing anybody other than myself. Seated in the second row is my brother Brian. Last summer, he was riding his bicycle when he was hit by somebody who was talking on a cell phone. He spent 10 weeks in the hospital, and the bills were over $300,000. Because the driver was underinsured, but because he's a disabled adult and I am his caretaker, it actually turns out that my insurance paid for most of his medical bills. I, as a police officer, recall when the cell phone law first came into effect, there was about a 3 or 4 week period when you couldn't see anybody talking on a cell phone. And after that, it resumed. I could go spend a 10-hour shift and write 50 cell phone tickets if I wanted to, and occasionally I do. However, I've seen other people, to include members of the bar and judges themselves, talking on cell phones going down the street. I believe the teeth in this bill is when it adds a point to your driver's license, because that affects your insurance for 2 or 3 years. And I also believe that's going to compel parents to stop paying for the cell phone bills of their children if, in fact, their children get a ticket for talking on a cell phone. Thank you for your time.
Thank you. Other witnesses in support?
Mr. Chair and members, Paula Labrie with AAA, also in support. And we believe that the penalties here need to be consistent with other types of penalties, other moving violations, because otherwise the motorist will think, well, it's a lesser penalty, so therefore the violation is not as significant, and that's the wrong message. We want to let them know that these are very significant violations, and therefore the penalty should be consistent with other types of moving violations. So we are in support of the bill.
Thank you. Other witnesses in support?
Mr. Chairman and members, Gabe Robertson, representing the Driving School Association of California, the California Traffic School Association, and the Traffic Safety Consultants, Inc. We're in very much support of the legislation. We've been appalled at the number of drivers we see holding a cell phone to the ear while driving, and we've been very concerned about that for a number of years. We concur with all the comments by the previous witnesses, are in strong support. Thank you.
Thank you.
Mr. Chair, members, Doug Houston with the California Bicycle Coalition. We are supportive of this bill in concept. We understand that there may be some amendments pending.
We'll talk about those.
Very good, and that would probably take us to support. Thanks very much.
Mr. Chairman, members of the committee, James Lombardo on behalf of the California Association of Bicycle Organizations, and as my colleague shared with some amendments, we'll probably be in support of the bill.
Thank you. Are there any witnesses in opposition? Senator Simitian, before I just go on, Senator Simitian, we would like you to take two amendments. First of all, we're very supportive of the bill. We think that penalties, as you say, should be consistent with the punishment should fit the crime, and yet be at a level that effectively alters behavior. So there are a couple of issues, but not be so punitive. The first one is in item number 5 on page 4 in the analysis. We talk about different fines for texting and talking. What we'd like to do is to make the fines for texting and talking on a handheld cell phone equivalent for drivers per comment 5, so that we have a consistency between both texting and talking.
Mr. Chairman, if that's the suggestion of the chair, I'm happy to take the amendment. I do want folks to know, however, that these are still pretty modest fines by comparison to other parts of the country.
Right. What we're talking about now is increasing the fines now to, I think, $50 and $100, which by the time it's $255 for a $50 fine and $445 for a $100 fine. So we would like that to be consistent.
And I'm happy to take the amendment, but I do want folks to know, just as an example, in Utah, the base fine for texting is $750 because it is deemed to be that dangerous. In New York, Indiana, Connecticut, there are proposals either from the governors or the legislatures in those states to move to $500 fines. And in Utah, if there's an accident, then it is texting is considered a felony for purposes of prosecution. So
after we have raised these fines, again, the committee, if these are not effective, we would be open to reconsidering these issues.
Happy to take that as an
We're
option.
already making significant increases. The second issue is we think that there is a difference between bicyclists and drivers who already have driver's licenses. And so what we would like to do is to establish lower penalties for bicyclists to address some of the concerns that were raised in item 3. Specifically, the amendments would apply the same penalties that currently exist for drivers. That's $20 for a first offense, $50 for subsequent offenses. Although those fines, if we today, what we'd like to do is the amendments would exempt from these fines all the assessments, fees, surcharges, or any other charges, so that the total fine for a bicyclist is either $20 or $50 to begin with. Yes, we can do that. We can exempt those fees because these are not going on their driver's license. These are not part of the motor vehicle, right? These are bicyclists. They do not get points, right? They do not have driver's licenses frequently, and so they can be exempt. We have checked on that. They can be exempt. So we would like to ask you to take that as an amendment for bicyclists.
Happy to take that as an author's amendment, Mr. Chairman, and you've underscored a question that has come up, which is the point on the driving record obviously does not apply.
It does not apply to bicyclists because frequently they are underage, and the way the fines would be set up is that we're talking about potentially, $200 to $300 for a bicyclist, and that may be more than. And we think that we'd be open to even changing that as we go forward in the future. We think this is a good first step, and if that's not effective. But we do think there is a difference between being a bicyclist and being a driver of an automobile. And frequently what happens is the bicyclists that are mostly the ones that are hit by people who are texting, and it's not that a bicyclist hits a car, it's the other way around frequently, that the car. But having said that, we think that no one should be texting or using their cell phone while either riding an automobile or driving an automobile or driving a bicycle. So with those two amendments, we'll ask you to work that out with the committee staff, the actual language, as this bill moves forward. So Senator Oropesa.
Okay, one of the questions was answered, that I had was answered already, and that had to do with the point, to just
Right,
clarify that
the points
bicyclists
are
do
not
not
for
get
bicyclists.
a point, because there's really no nexus between being a bicyclist and having a record that a point could be.
And you can't use a point for what?
Right.
They don't have, they frequently don't have driver's licenses.
I'd like to follow up on one of the observations that the chair just made in terms of the ability of the legislature to basically waive the additional, any or all of additional fees that are applied to violations in the vehicle code. This is new information to me. I was not aware that it was possible to basically, with fees or fines that are already in the code, in the transportation in the code, vehicle code, that we could actually. Can we pick and choose which
Those are
ones?
for motor vehicles. These are not, we're talking
But
about
this is in the
non-motor.
I understand, but it's in the vehicle code. Can somebody show me?
We've asked judicial counsel to opine, and they said this can be done.
Okay, because there may be the reason why I'm asking is there may be other cases in which this is an appropriate thing to do, and so I'm trying to find. I'd appreciate the help of your staff, perhaps.
Our staff would.
in
We've
defining
raised that
some
same
parameters.
issue, and we asked for this particular case for a legal opinion, and we were told that this would be for bicyclists, would be acceptable.
So maybe we can, maybe in working with staff and legal counsel, I can get a little more guidance on what the parameters are.
Absolutely.
Because I think it's useful, frankly, to be able to differentiate. I don't know how that impacts, the fiscal end in terms of the recipients of those fines and fees. Because, of course, when we waive them, then those fines and fees are not received by the courts or whoever the fine or fee is dedicated to. It's not really relevant to this bill, but it brings an important point that I think I would personally like to know for the future. So appreciate your help on that. Finally, I would like to say that I do believe that it's important for us to be fairly assertive and strong relative to bicyclists. I frankly think the risks of super harm to an individual or group of individuals by texting while you're bicycling is maybe even more severe than in a car, because one doesn't have as much control on a bicycle as you do in a car. So, I mean, it's an arguable point, but I'm glad that we are including bicycles now in this effort. I hope that we don't have to give one citation, that the education process that occurs as a result of this measure is sufficient to say, look, folks, and maybe it will be better with bicycles than it is with cars, to say to bicyclists, look, don't do this behavior. And maybe we won't have to have one citation, which would be super as far as I'm concerned, because it's really in the end about the safety. But I'm happy to support this measure. I appreciate the chair's work on this with the staff, as I'm sure Mr. Smidian does, to make it an even better bill. And I'm delighted to move the bill if that's appropriate.
Absolutely.
At whatever point.
Any other questions by members of the Senator Huff?
Got so excited I almost knocked my coffee over. And I wasn't texting.
Show your hands. Show your hands. All right.
Well, this takes me back to a few years ago when we had this debate the first time around. And I'd like to start with just the penalties. As I recall, part of the pitch when the legislature is being entertaining this idea the first time was that we were making it a small penalty so that it would sort of fit the crime. Now, today I see that, the small penalty is trying to be ramped up and more to fit existing things. So there seems to be a little incrementalism going on after 4 years or 3 years, whatever it's been, has passed.
I take a slightly different view of the history of the bill, as you might expect, Senator. I was very clear then, excuse me, and I'm very clear today that I'm not interested in issuing tickets. I'm interested in saving lives. Reasonable people will disagree. I believe that we're saving lives every day, and I believe that we are reducing the number of collisions. But I said at the time, when people said, gee, that seems like a pretty modest fine, I'm not interested in raising revenue. I'm interested in saving lives. I am still in the same place today. Interestingly, there's been some question about whether or not this is designed to increase revenues. I want to be very clear about my own personal view on this subject. I don't think traffic tickets should ever be given to raise revenue. Let me say that again. I don't think traffic tickets should ever be given to raise revenue. I think traffic tickets should only be given when they're in the interest of public safety. I also think that members of the legislature owe it to the public to monitor how well their legislation works over time. So I have been, and this won't surprise you, buried in the data over the last few years to see what's working. Are there ways the bill could be improved? I deliberately did not come back with any suggestions in the last year or two because I wanted to give the bill time to work and see how well it worked and where there might be room for improvement. The issue of bicycles was an obvious oversight in my view because the code does provide that bicycles are on the natural, subject to the same rules and regulations as other users of the roadway. The issue of the fees and fines was an interesting debate. For years, I've had people criticizing me, particularly in my local newspaper, the San Jose Mercury News, for the fact that the fines were too modest. When were we going to do something about that? And what I said is, let's give the law a chance to work and see how it works. Now, the conclusion I came to is, I think the law works pretty well. I think we are saving lives. I think we are seeing fewer collisions. But I also think that for some people, the fact that the fine is relatively modest has not served as a significant deterrent, and that's why we see a significant number of folks who still don't comply. Now, that's also the reason for the point on the record, because for some folks who are a little more prosperous, they can take the risk of, I might get caught, I might not. If it's $125 after all the fees and penalties, I'll live with it. That point on the record, however, has broader ramifications and is something that everybody is concerned about based on my conversations with folks in the insurance industry and in law enforcement and our work with the folks at the CHP. So what I've done is what I think legislators should do, which is start out, take a modest approach, don't overreach, see how it works, and then when you actually have some evidence, build on that evidence, and then move forward. And again, I want to close by saying, I understand that nobody wants to get a ticket, and of course the easy way here to avoid getting that ticket is to talk all you want as long as you want, but do it hands-free. But again, the amount that we're proposing is half of what it would be for a littering violation, half of what it would be for a carpool violation, or half of what it would be if you tried to sneak one of your colleagues into the drive-in movies in the back of the trunk. I think that's a reasonable compromise given the concerns about ticket costs.
Senator Huff, do you have more questions?
Oh, yes, I do.
Oh, I
Thank you
can
very much,
imagine
Mr.
that
Chairman.
you do. You may have wanted to close, Senator Simitian, but that's not your choice.
And just to clarify, the $20 fee now, and you mentioned this, Mr. Chairman, is $141.
$1, right.
The 50, and that's base. Some counties have a little bit more. $50 translates to $255. $100 translates to $445. And there are a lot of people that have absolute sticker shock because they thought it was a small amount already. And I've talked to some of them that have been, driving in such a manner and cited for it, and it does cause them concern. But we'll just stipulate that I don't agree with the aggressive, more aggressive, I should say, fee level. And I also think the point is taking it way too much, way too quickly. So we'll just stipulate that and move on to the bicycles, and then we'll finally get to the principle of this is the hands-free phoning and texting. On the bicycles, how do you enforce this? How do you propose that be enforced?
A local police officer who is driving down the street in my hometown or yours would see a cyclist riding down the street in my hometown or yours, clutching that handheld cell phone up to their ear and would issue a ticket, just as they do right now for the vast majority of things that are covered under the code. If you look at Vehicle Code Section 21200, you'll find that it says every person riding a bicycle upon a highway has all the rights and is subject to all the provisions applicable to the driver of a vehicle by this division, including but not limited to. So essentially, the way the code operates is if you're a cyclist, you're subject to the rules of the road. The reason this slipped through the cracks was that when the language was drafted in 2006, it specifically referenced motor vehicle drivers by the language that the Legislative Council used. That, of course, was subsequently interpreted to mean motor vehicle drivers, as opposed to the more general application which ordinarily would apply to all cyclists. So just as the law currently says if you're going to be out there on a road in my hometown or yours, you're supposed to stop at the stop sign. You're supposed to go the right way on a one-way street. You're also now, if the bill becomes law, you're also now supposed to be hands-free if you're going to be on your cell phone.
And I would just say that's one more law that will not be enforced because all those things you cited that they should be doing are not currently enforced with any regularity, such as running stop signs, riding the opposite side of the street, or any of those other things, because there is generally perceived to be, at least with non-motor driven cycles, less of a degree of offense.
I'm looking forward to our conversation about the legalization of marijuana when that topic comes up, Senator. See how you feel about
that's a whole other issue
there.
But does this apply also then to skateboards? Does the existing law apply to them when they're in a public right-of-way?
No, we have CHP here, and they'd be happy to respond if you'd like.
Would that be a similar kind of offense, though, or distraction?
Not to my knowledge. Excuse me, in terms of this, if you're asking me, do I think it's good behavior? I'd say the answer is no. If you're asking me, is it covered by my bill?
So
again,
bicycles are, but skateboards aren't, as far as what's legally enforced here.
I think at this point I ought to defer to the CHP.
Is the CHP representative here?
Yep.
Come on up.
Take your skateboard. That's next.
Good afternoon, Mr. Chair, Mr. Huff. Captain Brown with the California Highway Patrol.
And
we do not have an official position on the bill, sir.
Okay. Don't go away yet. So are skateboards, they fall under any of these laws, or is it just bicycles that fall under the vehicle code?
Skateboards and the operation of a skateboard on a road or roadway would fall under certain provisions of the law. As we look at this particular statute, the skateboards would not be included. By definition, as the author said, when you look at the vehicle code under section 231 or you go over to section 415 of the code, it defines or makes a differentiation between a vehicle and then a motor vehicle. The bicycle is considered a vehicle because it's propelled by human power. There is no mechanism, machinery, or engineering that goes into it and uses a belt or a chain to move it. By having section 21200 in the vehicle code, it specifically articulates that the rules of the road within Division 11 apply to bicyclists. So that's why this statute could extend and could apply to the bicyclist, whereas a skateboarder is not subject to those parameters as outlined in 21200 or articulated in the definition sections of the code.
Okay. And then how about the electric or gas-driven little scooter that, we used to have a problem with a few years back?
Those electric or gas scooters, again, when you go back and you define by definition, there's a specific exemption that's granted for those types of conveyances if they're being used, or exceptions from the code, by disabled persons. If they're not, then they have to comply with the rules of the road. So they have parameters under which they may use or operate when they can or cannot be on the road versus the roadway. And it's very important to understand when we talk about road and roadway. Roadway is property line to property line, whereas the roadway falls between what we consider the white lines and the yellow lines, that portion maintained for normal vehicular travel. So things could move on the shoulder, but could not cross over to the left of that solid white line and enter what we call the roadway, so the laws would not apply there. But if they were not being operated with their exemption for the disabled individuals, then they could also fall under the parameters of the code. But here in this statute, you're specifically looking at the bicyclists on the roadway.
Okay. Very good. Thank you for that. It does beg the question, while you haven't written this way, but what about pedestrians in crosswalks? Should they, because when they're walking across either in a public right-of-way, particularly in a street where they can come in conflict with a bicyclist or a motorist, would that not be a reasonable extension of what you're trying to accomplish here to preserve public safety?
Senator, I think I'm going to limit my reaction or remarks today to the bill I have before you, not a bill that I have not proposed.
I'm just wondering what we're going to see next year also.
And I tell you what I'll do, Senator. I'll give you an ironclad commitment. You will never see a bill from me on hands-free cell phones or texting involving pedestrian behavior. You can sleep a little sounder tonight, sir.
Thank you. That does give me some level of comfort, although a little bit.
There you go.
Thanks. Gimme. All right. Moving on to then the hands-free, the increase in the penalties and the texting. You were citing some data early on. Did you take into consideration the economy or less traffic moving on the roads?
I'm so glad you asked, Senator.
Good.
Yes. In fact, the obvious question is there, one of the things we looked at when we saw those good numbers in terms of the reduced fatalities and the reduced collisions is, are there some other explanations? And one of the questions was, looking at the data in 2008, what are the miles driven like? And here's what we discovered. The miles per capita, not per driver, but per capita in California, was 99.7% of the miles per capita in the year 2000. So virtually flat 8 years later. However, there was a 7.9% increase in the total number of licensed drivers, and of course there was about a 3.5 to 4 million population increase, which means that you have dramatically more miles being driven even as we were able to achieve that reduction in fatalities and that reduction in collisions. Now, what makes those numbers even more dramatic, in my view, is that between the year 2000 and 2008, there was a 125% increase in the number of cell phones out there. Makes sense. Cell phones got less expensive. People started to use them. And there was a 5-fold increase in the total number of minutes, which means that with more people driving more miles, same number of miles per capita, but more people driving more miles with more licensed drivers, dramatic increase in the number of cell phones, and an extraordinary increase in the total number of minutes, we were still able to achieve those 20% savings averaged out over 3 years. And then, of course, because I wanted to make sure the data was good, Senator, I said, well, let's make sure it's not just compared to the last 3 years. Let's go back and look at the last 5 years and make sure that the same kinds of reductions hold, and they did, whether you compared them to the last 3 or the last 5 years. As we look at the numbers that are still coming in, because I wanted to make sure it wasn't a blip on the screen, the numbers are steady in the same direction. Can't give you final numbers because, as the CHP representative will acknowledge, they don't certify their numbers until the end of a calendar year, a year after. So the 2009 numbers won't be certified until the end of 2010, a whole year later. But the trends seem to be continuing, both in terms of the reductions in fatalities, the reductions in collisions, and the reduction in CHP cell phone identified distracted driving accidents.
Was this you and your staff that were compiling the data? Data from the CHP, and then you guys are crunching the numbers?
This is data that we got from the CHP, and in some cases it was raw data. In some cases it was already laid out in what we would consider user-ready format.
Did you look at any other states who have not put this into effect to see how they have, what their data has been in the same time period?
We didn't do a comparison with other states who haven't done this yet, and it becomes hard because, as the officer will tell you, I feel sure, different states have different data collection regimes, which makes some of these comparisons difficult. But what we did look at was the PPIC study that I referenced, the Public Policy Institute of California, which I think most of us think is well-regarded, nonpartisan, no axe to grind. And they looked at the 4 other jurisdictions, New York, New Jersey, Connecticut, and the District of Columbia, who had passed hands-free bills and they looked at their experience just before California law took effect. And what they discovered was that in all 4 of those jurisdictions, there were, in fact, reductions in the number of fatalities in every jurisdiction over every time period they reviewed. So whether it was a 6-month period after the law passed, a year after the law passed, 2 years after the law passed, they saw those reductions. Now, there was a study that came out just within the last few months from the Insurance Institute that suggested that there was no reduction compared or contrasted with other states. Let me tell you that AAA actually did a very nice job of critiquing that study, but let me tell you what that study didn't do. It didn't look at any crashes related to cell phone use. In fact, it didn't have any crash data at all. In fact, what it had was claims data. In fact, what it had was claims data limited to new cars, which are not a sample across the spectrum. And then, in comparing or contrasting that data, it compared and contrasted it with, I believe it was, Oregon, Nevada, and Arizona, which are not exactly templates for California, which is why that particular study, while it got quite a bit of airplay, wasn't really a particularly good study to use when we're looking at real crash data in California, real fatality data in California, which is consistent with the experience of 4 other jurisdictions as laid out in the PPIC study. The one study that actually looked at what happened when people passed the law.
Well, it's good you mentioned the insurance industry. There was a couple of things they said, and the important thing was the Highway Loss Data Institute study finds no reductions in crashes after handheld phone bans take effect. Comparing insurance claims, as you said, for crash damage in 4 U.S. jurisdictions before and after such bans, the researchers find steady claim rates compared with nearby jurisdictions without such bans. And they went on with a lot of other stuff, but they said this method controlled for possible changes in collision claim rates unrelated to the bans, changes in the number of miles driven due to the economy, seasonal changes in driving pattern, etc., which just the raw data is not going to collect. AAA's comment on that was actually more that it was inconclusive, and even in the testimony today, they said they supported this because it upped the rate of the fee, and in the letter they said they supported it because of the educational aspect of it. Nowhere did they say because it would reduce traffic, related accidents. And so if the conclusion that was on that study is whatever the reason, the key finding is that crashes aren't going down where handheld phone use has been banned, this author points out. This finding doesn't augur well for any safety payoff from all the new laws that ban phone use and texting while driving. The Governor's Highway Safety Association said that it was unclear, but they represent highway safety offices in the 50 states, and they urge states to pass texting bans, which we already have, but hold off on addressing other cell use until some clarity is achieved. Well, we've already got all these bans in place, and now we're ramping up when the data is still inconclusive from people that are in this business for a living. And I'm sure they have, plenty of researchers to look at and crush the data and take a look at their loss. They make a living on whether or not they're accurately predicting losses. So I just think that we are being premature in upping the ante on this. You did state that you can't prove that it's causal. You also said that you're interested in saving lives, as they believe we all are, but the data is inconclusive about whether it actually does that or not. So I would say that the timing on this is probably premature. And for those reasons, in addition to I didn't like it in the first place, the whole idea is driving distracted. And there was a 2000 study that showed cell phone use increases accidents 4-fold. That's significant. But combing your hair, fussing with the CD player, the radio are also driving distracted. Eating a McDonald's sandwich, all the things that crazy drivers do, and if you've ever commuted very far, you see it all. Those are the things that cause accidents. But there hasn't, at least according to this study, documented that driving hands-free versus holding it up to your ear makes a bit of difference, and yet we're going to ramp up the consequences for doing that. And I just think that's not the right place to go.
Thank you, Senator Huff. Are there other questions or members of the committee that wish to ask any questions? If not, as amended, the bill has been, and then I'll ask you to respond to that, has been moved by Senator Oropesa. Senator Simidian, would you like to respond and/or close?
By way of a close, thank you, Mr. Chairman, and thank you, members, for an extended conversation. The study that is referenced, which I referenced a moment ago, I want to underscore, does not look at any crash data. None. And it says so in the précis that they outlined. In fact, while they drew the conclusions that were read out loud, in New York, they actually did find some improvement, but then tried to explain that away in the same study. And I would encourage any of you who are interested, ask us, we'll give you a copy, and we'll highlight that particular part of the study. But again, the question isn't whether or not you can find a study or more. You can find more that question the effectiveness of hands-free. I don't doubt that. But there isn't a study in the world that says you are safer clutching a handheld cell phone to your ear while you are distracted by your conversation. That study doesn't exist because it defies logic and common sense. What we've got is actual crash data. And just to clarify what I said, I didn't say I couldn't prove the impact. I said I couldn't prove it to an absolute certainty because there will always be doubters and skeptics. But we looked at the number of miles driven. We looked at the experience in other states. We looked at the CHP data that has been collected monthly since 2001 and saw that while there was no drop in distracted driving accidents related to the radio, the kids, the pet in the car, there was a 40 to 50% drop in the number of accidents attributed to cell phones. I think there's a causal relationship between that change that occurred literally overnight once the new law took effect. Here's what I want to go back to, Mr. Chairman and members. 75,000 to 100,000 fewer collisions every year. 700 fewer fatalities. I know these are only statistics, but to try and make the statistics a little bit more real and a little bit more personal, what that means is that every single night, somewhere in California, 2 people are going to sit down to dinner with their families who otherwise wouldn't have made it through the day. And I think that's worth a moment of care and common sense. I hope you do too. I respectfully ask for an aye vote.
Thank you. Will the Secretary please call the roll on SB 1475 as amended?
Lowenthal.
Aye.
Lowenthal, aye. Huff.
No.
Huff, no. Ashburn. DeSaulnier.
Aye.
DeSaulnier, aye. Harmon. Kehoe.
Aye.
Kehoe, aye. Oropeza.
Aye.
Oropeza, aye. Pavley. Simidian.
Aye.
Simidian, aye. 5-1.
That bill has sufficient votes for passage, but we're going to hold the roll open for the absent members. Senator Simidian, thank you.
Thank you very much, Mr. Chairman.
I believe our last author is the Honorable Senator Chris Kehoe. And Senator Kehoe has 2 bills. Please begin with item number 4, SB 1340, on alternative fuels and vehicular technologies.
Thank you, Mr. Chairman. Members, this is a pretty simple bill. I don't usually say that, but this one really is. It requires that the California Energy Commission create a program to defray the cost for residential electrical upgrades that may be required for consumers who purchase an electric vehicle. The transportation sector accounts for almost 40% of our greenhouse gas emissions, and we've recognized the importance of finding clean alternative fuels to replace our dependence on petroleum fuels and the resulting pollution. It is in the state's best interest to encourage consumers who purchase electric and hybrid electric vehicles to lend some financial assistance towards the needed electrical upgrades in order to install the charging devices in their homes, or in their garages, rather. The CEC is eligible to do this now through the 118 program, but they don't. We've been in communication with them. They'd like to have it in statute. That's what the bill does. I would ask for your aye vote.
So what you're saying is that this both clarifies and states definitively that AB 118, that the CEC can use funds for home electric charging stations.
To defray the cost of those installations, right. We have support from the Sierra Club, the Bay Area Air Quality District. I think they're here in support of the bill.
Well, let's have them come on up.
It's also referred to environmental quality.
Let's have them all come on up. Witnesses in support. Don't be shy.
Good afternoon, Chair and members. Tom Addison with the Bay Area Air Quality Management District in support.
Adam George with Sierra Club, California.
Can you turn on your microphone,
Push
please?
the red button, yeah.
That's it. Now you can.
Adam George with Sierra Club, California in support.
Thank you.
Jamie Kahn with Nissan North America in support of the bill.
Thank you.
Thank you so much.
Jamie, can you have Nissan send us a letter? We don't have anything. We do not have a letter in the file, and I think it'd be helpful for us. Thank you. Can you give that to the sergeant or the letter, and give that to the staff member? Are there other witnesses in support? Are there any witnesses in opposition? Members of the committee wish to make?
Thank you.
The bill has been moved. This bill has been double referred to EQ, so the motion is to do pass and refer to environmental quality. That's exactly what Senator Oropesa meant. She knew. She just needed to be prompted. With that, if not hearing any, Senator, would you like to close?
Ask for your aye vote, Mr. Chairman.
Will you please, Secretary, please call the roll?
Lowenthal.
As amended?
No, not as amended.
No, it's not amended, but double referred to environmental quality, not amended. Aye.
Lowenthal, aye. Huff. No. Huff, no. Ashburn. DeSaulnier.
Aye.
DeSaulnier, aye. Harmon. Kehoe.
Aye.
Kehoe, aye. Oropesa. Oropesa, aye. Pavley. Semidian.
Aye.
Semidian, aye. 5-1.
The bill has 5 votes sufficient for passage, but we're going to hold the roll open for the absent members. Senator, I believe that you have one other bill, and that's SB 1394, item number 6.
Thank you, Mr. Chairman. And members, under current law, there are various conditions describing when a peace officer or a local parking enforcement officer may remove vehicles that are illegally parked. In some situations, a peace officer may have a vehicle towed from a highway if the driver is physically injured or too sick to move the vehicle themselves. In other situations, an illegally parked vehicle that is blocking access, say to firefighters accessing a hydrant, may be moved or towed at the firefighter's instructions. SB 1394 modifies these situations by clarifying that in addition to firefighters, vehicles that are illegally parked and obstructing access to other first responders, such as police, ambulance drivers, and EMTs, and other emergency vehicles, those vehicles may be towed or removed. This clarification ensures that, ensures that vehicles have access, the access they need to respond to an emergency. Mr. Chairman and members, we had some language in the bill that added cognitive impairment to those categories, such that the condition of the driver would make them eligible to have the car towed. We're going to delete that. We're going to delete that language on cognitive impairment. The other parts of the code describing, mental incapacity, injuries, or illness will stay as is.
Thank you. So we're going to take that as an amendment in this committee, so this bill will be do pass as amended. Members, other.
Thank you.
As amended, Senator Oropesa has moved all the bills today, and I would like to compliment her on that. With that, are there witnesses? She's right on top of it.
I would like to mention, Mr. Chairman, that the California Public Parking Association is in support, and we have late support from Orange County Professional Firefighters.
Are they here?
Association for the Los Angeles Deputy Sheriffs, and Riverside Sheriffs.
Witnesses in support. Don't hide. All right, they are hiding, but you've already indicated that there are witnesses in support. That will be duly noted.
Thank you.
Do you have witnesses in opposition? Do you want to give that list also, Senator?
No, thank you.
Okay. Not hearing any witnesses in opposition and not having the senator list those for us, are there members of the committee that wish to ask any questions?
Pretty straightforward.
The bill has been moved as amended by Senator Oropesa. Would you like to close, Senator?
Ask for your aye vote. Thanks, Jimmy.
Secretary, please call the roll on SB 1394, legally parked vehicles, as amended.
Lowenthal.
Aye.
Lowenthal, aye. Huff.
Aye.
Huff, aye. Ashburn.
Thank you,
DeSaulnier. Harmon. Kehoe.
Aye.
Kehoe, aye. Oropesa. Oropesa, aye. Pavley. Pavley, aye. Semidian. Semidian, aye. 6-0.
Bill has 6 votes sufficient for passage. We'll hold the roll open for the absent members. Members, that concludes the presentation of bills. We're going to hold the roll open for 10 minutes now. I'm going to lift the call on all the bills. I will keep the roll open for another 10 minutes after we do that, and then this meeting will be adjourned. Okay, with that, Secretary, let's lift the call. Let's start first with SB 1216. Senator Cedillo, if the Secretary will please announce what the chair voted and what the vice chair voted.
Current vote, 5-0. Chair, aye. Vice Chair, aye. DeSaulnier. Harmon. Kehoe.
Aye.
Kehoe, aye. Pavley. Pavley, aye. 7-0.
Bill has 7 votes. We'll hold the roll open for a few more minutes. And we'll replace the call on that. Next bill, SB 1268, item number 3, Senator Semidian. Present vote is?
Current vote, 6-0. Chair, aye. Vice Chair, aye. DeSaulnier. Harmon. Pavley. Pavley, aye. 7-0.
The vote, again, has sufficient votes for passage, but we'll replace the call on SB 1268. Next item is item number 4, SB 1340, Senator Kehoe, Energy, Alternative Fuels, and Vehicle Technology.
Current vote, 5-1. Chair, aye. Vice Chair, no. Ashburn. Harmon. Pavley. Pavley, aye. 6-1.
That bill has 6 votes, sufficient for passage, but we're going to replace the call. Next, item number 7, SB 1475, Senator Semidian.
1394.
Oh, I'm sorry, Senator. We'll do item number 4, SB 1340, Senator Kehoe. I thought we just did that.
No. 1394, we're missing item number 6.
That's what I just said.
No.
We're going to go to item number... Oh, I'm sorry. Let's go to item number 6, SB 1394, Senator Kehoe.
As amended, current vote 6-0. Chair, aye. Vice Chair, aye. Ashburn. DeSaulnier. Harmon. 6-0.
The bill has 6 votes sufficient for passage, but we're going to replace the call on that and wait for another 10 minutes for the absent members. Finally, we have the last bill is we have the consent calendar also. Item number 7, SB 1475, Senator Semidian.
As amended.
As amended.
Current vote 5-1.
I believe, is that? Right, and that's not...
And the fines, and the level of fines.
Right, I was just saying whether that's been dual referred, but I don't think so. Okay.
Current vote 5-1. Chair, aye. Vice Chair, no. Ashburn. Harmon. Pavley. Pavley, aye. 6-1.
We'll replace that vote, again, has sufficient votes for passage. We'll replace the call on that and wait for a few minutes for the absent members until 3 o'clock. The final item today before us that we're going to lift the call on is the consent calendar, items 8, 9, and 10. 2 of the items, item 8 and I believe item 10, have technical amendments.
Current vote 6-0. Chair, aye. Vice Chair, aye. Harmon. Kehoe.
Aye.
Kehoe, aye. Pavley. Pavley, aye. 8-0.
The consent calendar has 8 votes. We're going to replace the call, though. That is sufficient for passage, and we're going to wait until 3 o'clock. At such time, this meeting will be adjourned.
Thank you, sir.
Thank you, members. We have finished all the business of the day.
Thank you, Mr. Chairman. Did I miss 1 or 2?
I think you're done. I think you're on all of them, Chris.
National Council of Environmental Legislators sending a letter
Yeah, that means put my name on a letter, which forever my name is attached to, and I have to be able to vouch for what's in the letter. And it's a page and a half long of stuff that I have no idea what the hell we're talking about. Have you looked at this? What do you think?
I briefly looked at
Do they
it
need to hear from us?
tomorrow.
Then the answer is no. Did they just let us know?
Yeah.
Yeah, tell them.
The only reason I brought this to you.
Tell me the answer is no. Doesn't matter. I don't care if it's yourself. Tell them the senator does not do, it's rare that I use the senator, but the senator does not do 24-hour turnaround on the Board of Public Life.
Okay.
Okay, try again.
Yeah.
Okay, is that sufficiently grouchy?
And perhaps not to be that crafty when I say it.
That's why we have staff to be charming.
But I appreciate you showing her. Oh, too bad. She looked me on the note last night at the door saying she was going to be there. She's a nice person.
Okay, so just, Senator Herman is not coming.
Okay, we're gonna open the roll right
So
now.
you can just open the roll and then close everything down, okay?
We're going to open the roll and lift the call and all the items that remain on call. We're going to start with Senate Bill 1216. Senator Cedillo, please tell us what the vote is now.
Current vote 7-0. Chair I, Vice Chair I. DeSaulnier.
Aye.
DeSaulnier, aye. Harmon. 8-0.
That bill has 8 votes. That bill is out. Next, SB 1268, Senator Simitian.
Current vote 7-0. Chair I, Vice Chair I. DeSaulnier.
Aye.
DeSaulnier, aye. Harmon. 8-0.
Bill has 8 votes. That bill is out. Next, SB 1340, Senator Kehoe.
Current vote 6-1.
Bill is double referred to EQ.
Current vote 6-1. Chair I, Vice Chair no. Ashburn. Harmon. 6-1.
The bill has 6. What about the Sony?
He voted on that.
Okay. That bill has 6 votes.
I hear people say that a lot. By the way, you'd make a great umpire.
Excuse me.
The way you say that bill is out.
Oh, that bill is out. Okay, next is, now I don't even know which one we're on.
1394.
Okay, item number 6, SB 1394, Senator Kehoe.
As amended, current
As
vote
amended.
6-0. Current Chair I, Vice Chair I. Ashburn. DeSaulnier.
Aye.
DeSaulnier, aye. Harmon. 7-0.
Bill has 7 votes. That bill is out. Next, SB 1475, Senator Simitian, as amended.
Current vote 6-1. Chair I, Vice Chair no. Ashburn. Harmon. 6-1.
Bill has 6 votes. That bill is out. And now the consent calendar, which are items number 8, 9, and 10. 2 of the items have technical amendments.
Current vote 8-0. Chair I, Vice Chair I. Harmon. 8-0.
Bill has 8 votes. That bill is out, and this consent calendar is approved. This committee is adjourned.
You're welcome. Thank you for allowing me to come back. So